You signed a prenup before you got married, but now you're facing divorce and you're wondering, will this agreement actually protect me? Or can it be thrown out? In this video, I'll discuss when prenuptial agreements hold up in North Carolina courts. They don't. What makes the difference between an enforceable contract and a worthless piece of paper? I'm Gray Ellis, founder and managing partner of Ellis Family Law. For nearly 20 years, our firm has helped thousands of families across North Carolina protect what matters most through some of life's toughest transitions. If you're facing a divorce or custody dispute, give us a call here at Ellis Family Law, 919-688-9400. First, let me be clear. Prenuptial agreements are legally binding in North Carolina when they're done correctly. North Carolina law does recognize and enforce these agreements. They're contracts. Courts should only respect contracts between adults. But there are times that the prenup may be set aside. One reason is lack of full financial disclosure. Both parties must provide complete, honest information about what they own before signing the agreement. That means disclosing all bank accounts, retirement funds, real estate, businesses, investments, and everything of significant value. Hidden bank accounts, undisclosed businesses, or conveniently forgotten retirement accounts can potentially set aside the entire prenup. If you told your fiancé you had $50,000 in savings, but you actually had $500,000, that prenup is in serious trouble. Court will view that as deception, not negotiation. And when one person discovers after the separation that their spouse wasn't honest about their finances, the judge can throw out the entire agreement. Another major issue courts look for is whether the agreement was signed voluntarily. You can't be pressured or rushed into signing a prenup. That means the agreement shouldn't be presented the day before the wedding. Both people should have time to review the document, understand what it means, ask questions, and potentially negotiate the terms. When a person is put in an impossible position, either sign this document right now or cancel the wedding in front of your family and friends, makes it difficult for the court to enforce. When a prenup is challenged, the judge will look at the timeline and circumstances around the signing to determine if it was truly voluntary. North Carolina doesn't legally require both parties to have separate attorneys review the prenup, but it may make a massive difference in whether the agreement will hold up. If only one person had an attorney and the other didn't, the unrepresented spouse can later claim they didn't fully understand what they were signing or that the terms were unfair. Having independent legal advice makes the agreement much harder to challenge later. When both people have their own attorney review the prenup before signing, it shows the agreement was fair, both parties understood what they were signing, and neither person was taken advantage of. Courts look much more favorably on agreements where both sides were actually represented by counsel. Even if everything else is done correctly, the actual terms of the prenup still matter. Courts won't enforce agreements that are extremely one-sided or what the law calls unconscionable. If the prenup says one person walks away with every single asset and the other person is left with absolutely nothing, the judge can decide that's unconscionable and refuse to enforce it, even if both parties willingly signed it. The key is whether the agreement was unconscionable at the time of the execution, not the time of enforcement. And by the way, any provisions in a prenup about child custody or child support are never enforceable. You can't contract away a child's rights to support or a fair custody arrangement. Finally, the basics still matter. The prenup must be in writing because verbal agreements don't count in North Carolina. It must be signed by both parties. And while notarization isn't always legally required, having the agreement notarized adds an extra layer of validity and makes it harder to challenge later. Sounds simple, but I've seen cases where people assumed a handshake agreement or an unsigned draft version counted as a prenup. It doesn't. If you have a prenup and you're getting divorced, don't assume it's automatically enforceable. Give us a call here at Ellis Family Law, 919-688-9400, or visit ellisfamilylaw.com. We can review your prenuptial agreement, tell you whether it's likely to hold up in court, and help you understand your options moving forward. And if you're already going through a divorce in North Carolina, don't make the mistakes that could cost you custody or assets. Watch this next video where I walk you through the top 5 mistakes to avoid during a divorce.